Hi, I'm Professor Mark Grabowski, and this short video lecture will discuss how media laws are made in the United States. There are 5 sources of media law: constitutional, statutory, administrative, executive, and judicial. Let's start with constitutional law. This refers to the law that comes directly from the United States Constitution and its amendments. In some cases, it might also come from the constitutions of the 50 states. A variety of constitutional amendments apply to the media, including the First Amendment, which protects free speech and freedom of the press. Second, there is statutory law. This refers to laws made by the elected government bodies, such as the United States Congress, state legislatures, county commissions, and city councils. On the federal level, congressional action affects intellectual property rights, such as copyright. To a lesser degree, Congress also has authority to make laws related to broadcast media, internet service providers, advertising, and political communications. State legislatures are responsible for making laws regarding libel, privacy, open records, cameras in the courtroom, along with some other issues. City and county governments can pass local laws, which are often referred to as ordinances. And these ordinances may regulate things such as where internet service providers can construct internet infrastructure, such as wires and cables, where newspapers can locate newsstands, and where advertising billboards may be located. One simplified explanation on the difference between constitutional law and statutory law is to say that constitutional law deals with large and abstract issues, while statutory laws deal with matters that are specific and concrete. For example, constitutional law is vague. The First Amendment, for example, provides freedom of the press. But what exactly does freedom of the press mean? Well, Congress, through statutory law, makes these vague concepts more concrete. For example, Congress passed the statute known as the Freedom of Information Act, that provides journalists with access to government records. The third source of law is administrative law. Administrative law refers to rules and regulations made by administrative agencies that are part of the executive branch of the federal or state government. After legislative bodies such as Congress pass a new statute, it's often up to an administrative agency to work out the details on how the law will work and to enforce it. For example, if Congress were to pass a new law requiring that all new computers be manufactured with environmentally friendly parts, the Environmental Protection Agency might determine which materials are environmentally friendly and which are not. Thus, the agency would affect policy. At the federal level, agencies that have responsibilities related to media law include the Federal Communications Commission, which oversees internet service providers, the Federal Trade Commission, which handles advertising and marketing, the Federal Elections Commission, which oversees political advertising, the U.S. Patent and Trademark Office, which is in charge of intellectual property, and the Department of Justice, which is responsible for crimes. Executive actions are the fourth way that laws can be made. However, typically actions taken by chief executives, whether it's the United States President, governors of a state, mayors of a city, or the manager of a county, have little effect on media law. For example, there are not many things that the president can do without congressional approval that would have a direct impact on the media, except perhaps in a grave national emergency such as a nuclear war. That said, the president can have an indirect effect on media law through appointments of judges to federal courts, including the Supreme Court, and through appointments of heads of administrative bodies, such as the Federal Communications Commission and the Federal Trade Commission. The final way that media laws are made in America is through the judiciary, or through judges. Courts can affect media laws in many ways. Sometimes when Congress passes a new law, it might be challenged by individuals. or by organizations such as the American Civil Liberties Union. A judge then decides whether the law is unconstitutional and should be disallowed. Sometimes people or organizations or companies may sue another party because they believe their rights have been violated. For example, a person might sue a journalist or a blogger for libel, and a judge will have to determine whether libel occurred. And sometimes people might be arrested for committing crimes, such as making threats, but they insist that they're innocent. Now, since every American charged with a crime has a right to a trial, a judge will then hear a criminal case and decide whether any laws have been broken. These court rulings are sometimes referred to as case law or judge-made law. Most areas of media law are neatly divided among the federal, state, and local levels. But because of the broad nature of the media industry, certain categories of media law are assigned to each of the three levels, and in some cases, responsibility is shared. So now you have an idea of how media laws in America get made. Once again, this has been Professor Mark Grabowski. If you're in my media law course and have any questions, feel free to shoot me an email. Thanks for watching.